they weren't chosen by accident. Jurors in Disguise, a jury investigations podcast, exposes jurors who lied their way onto the jury to secure a guilty verdict. Each episode, owner and founder Mary Rose Peterson pulls back the curtain on real cases, revealing misconduct buried in lies beyond the gavel. Visit us on YouTube at youtube.com/@juryinvestigations.
Hello and welcome to another podcast of Jurors in Disguise. My name is Mary Rose Peterson, and I own Covert Ops Jury Investigations. In this podcast, I'm going to talk to you about what happens once you are convicted. I'm going to focus specifically on cases in Florida because that's where our case was, and that's where most of our clients' cases are. When the jury comes back into the courtroom and finds you guilty, what happens next? Martin and I could not believe what we heard. In fact, I was so stunned by those words that I couldn't even remember how to get home. I had to follow a friend. We have had clients who have called within hours of being convicted, and they could not even remember after a 3-week-long murder trial whether they had 6 or 12 jurors. So you go into shock. Sometimes you are sentenced immediately. Sometimes you are not sentenced for several weeks, or in our case, it took 5 months to get to sentencing. Once you are convicted and sentenced, the jurisdiction switches from the trial court to the appellate court, and your trial record is sealed. That means you cannot add anything to the record. You cannot add any new evidence or new information to the record. It is what it is. I'm not an attorney, but I know that because we went through this process, as have all of our clients. The misconception about the appellate court and the 3 judges is that they are going to retry your case, that they are going to look at all the facts, they're going to look at what's presented at trial, and they're going to realize that the jury made a horrible mistake. The direct appeal can take several months. In our case, it took 3 years for us to be. What we did not know then is that when those 3 appellate judges decide that your appeal is denied, they don't have to tell you why. They don't have to explain what went into their decision to deny you. You simply get a piece of paper that says per curam affirmed, which means in prison terms, you got PCA'd. That means you got denied. They upheld the lower court. I am told by our public defender that only 1 in 600 cases ever makes it back to the lower court. Nearly 600 cases out of 600 are denied by the appellate court. So your odds are terrible of winning. But you hold on to that hope. In our case, for 3 years, we held on to that hope that they were going to decide that the testimony of Martin's accuser was inconsistent and ridiculous. Nope. They upheld the lower court. During the time span where you are waiting for the appellate court to decide something, you are not provided any of your records. The procedure in Florida is that you are only provided copies of your permanent record, your transcripts from trial, which may or may not include the voir dire. Ours did not. You are not provided those transcripts until after your direct appeal is decided. Like I said, that could take a while. I want you to keep that in mind as I tell you later why our judges are denying the motions that our clients' attorneys are writing based on the juror misconduct that we have found. So your direct appeal, ours took 3 years, we were denied. The next step in the process is to declare that your trial attorney was ineffective. So the next step is for you to file a motion saying that your trial attorney was ineffective and did not represent you well. The flaw in that is that if your trial attorney is asked to explain him or herself and simply says, that was my trial strategy, that was my courtroom strategy, I chose not to object to that, I chose not to call that witness, I chose not to do this, I chose not to do that, that was part of my courtroom strategy. If they say those words, then they're pretty much off the hook. So it's very difficult not only to win a direct appeal, nearly impossible, but it is very difficult to win a 3850, as they call it, a 3.850 in Florida. So for many of our clients, they reach out after 10 years, 20 years, 30 years, and say, what can be done? Very few of them have any transcripts left. They have been destroyed by various means or sent home, and the person responsible for those transcripts either misplaced them or moved and threw them away or has passed away and nobody knows where they are. So we rely on the Clerk of Court to help our clients acquire copies of those transcripts. And court reporters in Florida only keep their records for 10 years. So here you are, stuck in prison. You need something new. You need new evidence to get you back in court through a motion so that you have a chance to re-argue your case. That's where we come in. We look for juror misconduct that can be used as a vehicle to get your case reopened and get you back in the courthouse. The juror misconduct that we uncover is egregious. It is shameful, the things that these jurors have come in and lied to the court about. There is no doubt, based on not just my opinion, but the facts, the hundreds, sometimes nearly 1,000 pages of exhibits that we provide with the report that shows this juror was not truthful. They came into court, they took an oath and swore to tell the truth, and then lied to everyone's face. What excuses are the judges giving for denying our clients' motions based on the juror misconduct that we've uncovered? I'm glad you asked. That this evidence, this proof of juror bias, could have been found sooner with due diligence by either the defendant or the defendant's attorney. Really? How is that possible? Our clients are in prison. Some of them have been for a very long time. They no longer have their records. The Clerk of Court often doesn't upload the records to the docket so that you can download them for free. They want the families of these defendants to pay for records at $1 a page, which can amount to thousands of dollars. So that I tell everyone, from the time we begin an investigation until the time we finish successfully, it's on average 6 months. It takes 6 months for us to locate and prove juror misconduct, juror bias. Somebody in prison doesn't have that ability or the money, and their family shouldn't have to. But that's what the courts are saying. You could have found this sooner with due diligence. Does that seem ridiculous to you? Because it certainly does to me. But that's what they're saying right behind the... Again, it would be laughable if our clients weren't in prison, and these judges are saying it with a straight face, on paper. They don't explain how. They just say you could have. No, you couldn't. It's impossible. We have to start holding judges accountable. We have to also insist that state attorneys' offices hold jurors accountable who come into court and lie to everyone's face. It's a third-degree felony to lie to the court. Direct criminal contempt of court. Look it up. That's what I did. I was horrified. I knew that what our juror did to us was horrific. I knew that it was something I still can't wrap my head around it. But it's a felony. And yet, how many of our jurors have been held in contempt? 0. How many of our jurors have come back into court, testified, lied some more, and the judges have said, I thought they were fairly honest or honest enough? All of them. Kinda honest? Is that like being kinda pregnant? Look, people, either you are honest or you're not. And if you weren't honest 20 years ago and you come back in and lie some more, well, guess what? You have an agenda. The courts say we didn't prove actual bias. Really? Well, to me and to the attorneys who represent our clients and to our clients, if you came into court and lied to get on that jury, because if you'd told the truth, you would have risked being struck. If you did that, you had to be biased. There's no way that you could have followed the judge's instructions. There's no way that you were fair and impartial, because you weren't fair and impartial before you even got selected. You had already decided to lie. And you weren't embarrassed. It wasn't something you were embarrassed about. If what we find is something that the juror could say, well, I was just embarrassed about, guess what? We keep looking. We don't stop there. You weren't just embarrassed. You were either told or you took it upon yourself to conceal that. Because if the defense had known that, you never would have been allowed on that jury. You were inappropriate with a capital I. And yet, the judges are all saying they're sticking up for the jurors. Why is that? Why are they taking the juror's side? Why are they taking the state's side? Oh, that's right. The judges are the state. Big surprise there. Judges have rules. They're supposed to follow the rules. They're not following the rules. It's rules for thee, not for me. They are not following their own rules. We have to insist that they do that. Because if we don't insist that judges follow their own rules, then guess what? You can forget about the Constitution if you go to court. You can forget about your Sixth Amendment. You can forget about your rights. You don't have any, because the judges and the state and the witnesses and the jurors have already decided that you don't get to have rights. Your rights are over with. They're gone. In fact, that leads me to something else. If you have the right to be innocent until proven guilty, then why are you already in jail? Why are you already incarcerated? You have not been tried yet. You have not been convicted by a jury, but you're wearing that orange jumpsuit. That seems unconstitutional to me. How can judges expect jurors to come into court, tell the truth, be fair and impartial, and obey the laws that the judge outlines? How can judges expect jurors to do that when the judges are doing that? Jurors are not the only ones lying in court. I have watched state attorneys lie in opening arguments, lie in closing arguments, lie all through trial, lie during the hearings based on the juror misconduct that we found, lied to the judge's face. It seems to me that the judges are now lying, because all the things they tell the prospective jurors at the beginning of jury selection, the speak honestly, tell the truth, be forthcoming. If there's anything in your personal experience or background that we need to know about because of the nature of these charges, speak up. They don't mean it. That's a lie. They don't really want you to tell the truth, because they want you to lie, have an agenda, get in that jury room, and find the defendant guilty. Why is that? Because judges are the state. They want you to be convicted. They are so biased. Their bias is screaming on every denial that I read. So if you go into court and you think you're going to get a fair trial by an impartial anything, you can forget about it. The state is biased, the witnesses are biased, the judge is biased, and the jury is biased, all against you. It's a trap. How can we ensure that this doesn't happen going forward? Again, we have to hold judges accountable. Don't reelect them. Go into those courtrooms and sit and listen. It won't take you more than 5 minutes. You will know the character of the judge that's sitting before you in that black robe. And if their character is not something that represents the title honorable, vote them out next time. I thank you for watching and listening. Be sure to like and subscribe and share these podcasts so that others will know what's truly going on in courtrooms across America. That's all for now. Until next time, remember the courtrooms may be silent, but we won't be. We will speak up, we will speak out, and we will always speak the truth. Thank you. God bless.
All it takes is one to convict an innocent person. One Trojan juror, one biased agenda, one hidden motive. That's why we investigate juries. We identify the sinister players and expose them. Jury investigations. Our number one objective is to get you back into the courtroom, because a guilty verdict doesn't have to be the end of the story.